Hello, Mr. Hussein. Good morning.
Good morning, Mr. Joseph.
Nice to be here. Yeah, well done. I'm sure we're all getting set before we hit the ball rolling by exactly 12.
Yes, sir.
Yeah, is there any other moderator for today's session?
No, there is no moderator.
Okay. All right then. You can put everyone on mute.
Yes, I think she unmuted herself.
Oh, okay. Well done. We have we still have is it 2 groups or still 4 groups?
No, 2 groups. We have one group for AI and one group for FinTech.
Oh, FinTech. All right, that's fine. So I'm sure is it AI is going first or FinTech is going first?
Either can go first. Any of them.
Okay, that's okay. That's okay. Well done. It's very few minutes, less than 30 seconds to 12 o'clock. Yeah, so I want to welcome everyone to another beautiful combined session between the FinTech program for JIIPCC Mentorship and Internship Program in collaboration with the Artificial Intelligence Mentorship and Internship Program organized by JIIPCC. So today is going to be more like a combined session, and I'm very sure that it will be worth our while. We have excellent mentors who have seen it all in their different spheres of responsibility and their careers, basically, that will be joining us today. So I just want to encourage everyone, have an open mind, sit back, engage as much as you can. Let's see how we can actually take this to a different frontier. So basically, we'll be hitting the ground running. I can see that many of us are still not still not around. That's on today's session, but I'll just quickly proceed by introducing myself. My name is Obo Joseph. I'll be your moderator for today, and very quickly as well, in line with what we have to do today, I would quickly tell us about the program. JIIPCC Mentorship and Internship Program is quarterly. It's for students and young professionals across Africa. Mentees have the opportunity to access advice, training, networking, mentorship discussions from industry experts and mentors. The program basically is to encourage us to continue our personal development journey and also to help us to evolve across Africa and around the world. You can also watch our videos by searching for JIIPCC on YouTube and Facebook, hashtag JIIPCC MIP, that's Mentorship and Internship Program. In very quick words, the objectives are basically to provide access to quality guidance, resource materials, training, and the like. I'm sure that we've actually seen that all through the program. Is also meant to raise leaders, raise the next generation, to facilitate networking amongst mentors, mentees alike. I think that's basically the objective. So I'm sure that all of us have actually seen how this has cut across all the programs that we have had so far. It's week 5 already. Time flies, it waits for no one. So I would like to quickly introduce our mentors for today's session. Yeah, if we can have it up. So we have Mr. Mark Sikongwe. He will be a mentor for today's session. Mr. Marx is the founder principal of Everlaw Associates. He works extensively in the fields of arbitration, ICT, tech law, and intellectual property. He's a facilitator on the annual Infotech and Law course of the Nigerian Institute of Advanced Legal Studies since 2016. He has trained in advanced intellectual property law courses at the World Intellectual Property Organization Academy, and he is an accredited agent of the Nigerian Trademark and Patents Registry and has conducted IP registrations businesses since 2010. Beyond what we can see here of Mr. Marks, he's a whole lot more. I've had cause to listen to him, and hearing him engage with the mentors, it's a huge opportunity I feel the mentees should take great advantage of. We'll be having a second mentor for today. He's Eden Katz. Eden Katz is a scholar, activist at the forefront of shaping norms in technology policy through leadership roles in the academia, advocacy, community entrepreneurship, and industry for over 20 years, 2 decades. He was the first executive director of the Information Society Project, initiating the Access the Knowledge Initiative and social movement, where he is now an affiliate fellow in practice. At the Electronic Frontier Foundation, he has built out their global advocacy work as International Affairs Director. He co-founded a community hackerspace pseudo room in downtown Oakland, now part of the Omni Commons Cooperative. At the World Economic Forum, he developed the methodology for implementing multi-stakeholder consensus policy instruments in emerging technology throughout the Center for the Fourth Industrial Revolution affiliate network. He currently works with startups on operationalizing responsible AI governance, most recently at Credo AI as technology policy advisor. We are very excited and pleased to have Eden Katz and Mr. Marks today, who will be engaging with our mentees. So we'll just take more very quick other announcements. I'm sure that we all are already preparing for the end of year engagement between the mentees taking place both in Lagos and in Abuja. I would encourage us to participate and to find out how to enroll or register. I know for sure that it will be an exciting time for us to be able to network beyond meeting on Zoom. Having a physical gathering would also be nice. So I will take more of the announcements now. While that comes up, I'm sure that Group 1, the FinTech group, you're getting ready for your presentation while we take further announcements. Yeah, so you can also enjoy 30 minutes one-on-one mentorship with your favorite JIIPCC mentor. You can use the link and engage with us. Let's see how you can actually take advantage of that opportunity. Don't let the mentorship session be over without you taking part of, without you engaging with the mentors. You know, it's beyond what we do here on Zoom. So much more can be gathered, so much more can be learned, and the opportunity is yours to take. I think that will be all for now. Is there anything else? I think the last thing, yes. So we're still taking registrations for Q1 for 2023. I'm sure that we might be making another announcement if everything goes well for another addition to this list, including IP, artificial intelligence, energy industry, fintech, health tech, and law, patent drafting. Something else is cooking. I hope it cooks fast enough so that that announcement can be made. But I want to encourage us to invite our friends, our colleagues to be part of the JIIPCC Mentorship and Internship Program. So much. A lot of people have gone through this particular session, over 300 so far. Let's see how we can take it to 1,000. And I'm sure that as we continue to engage and post about much of what we do here, so many people would get the opportunity to be part of what JIIPCC is actually doing in transforming the lives of students and young professionals, young people across the continent, which is what we actually stand for. The last thing I would like to say is for the presenters, do well not to read your slides. As much as you can, try to engage with the opinions you already hold based on the research that you have. so that the slide presentation doesn't turn up to be something you're just reading, but something that you are more like explaining and you are engaging with the content itself. So thank you very much. I want to really appreciate all our mentees for putting the presentation together, and I want to welcome our mentors as well. So very quickly, I would like to call on group one. Let's get started. So I would like to know who's taking the presentation for group one this morning.
I think we have two group ones. So is either you are calling the AI or you are calling the FinTech?
Okay, let's go FinTech first. Let's go FinTech first.
Group one. FinTech group one presenter is Goodness Otun. I can see how it goes.
Yeah, good morning, everyone. Sorry, can everyone see my screen? And can anyone hear me? Okay.
Yes, we can see your screen.
Okay. Good morning, everyone. My name is Goodness Otun from Group 1, and today I'll be talking about intellectual property in the fintech industry. So this topic is actually a very broad topic, and due to my limited time, I'm just going to really focus on the areas that I believe is very, very important for us to know. So to begin, we all know what FinTech is. FinTech is financial services that is offered through technology. And we know that FinTech services keep on developing day by day, hours by hours, month by month. And we know that FinTech services are changing the way both businesses and consumers carry out their usual transactions. Now, one thing about FinTech is that it keeps on developing. And this is due to constant innovation. And this innovation leads to unleashing a new stream of a new creation of new services and products. Now, one thing about these services and products is that this is where intellectual property now comes in that there's a relationship between this innovation and intellectual property. But before I go into that, what is intellectual property? Intellectual property includes the intangible creations of the mind, such as inventions, artistic works. I say intangible because they are things not physical in nature. For now, let's say I sing a song from my head, or then I write a book. That is my intellectual property. And then intellectual property right is the right that the intellectual property owner owns. It is protecting his intellectual property. Now, one thing intellectual property rights us to do is that it strengthens the position and bargaining power by way of securing the inventive features in their products. Now, how does this now relate to fintech? Fintech companies hold several intellectual property rights that they seek to protect. In that, these fintech companies, they have intellectual property, and then they have to protect those rights. And one thing about those rights is that they not only assist in protecting technical innovation, they also boost the images and the value of the companies. And this in turn will attract investors. Now, I'm going to move into intellectual property rights that are relevant to fintech. So when I talk about intellectual property rights that are relevant to fintech, we have 5 major ones. We have copyright, we have patents, trademark, trade secrets, and industrial design. Copyright. What is copyright? Copyright is a right to the expression of ideas in visual or audio forms, or in simpler terms, it is simply the right to not copy. Remember when I said, that if I sing a song or write a book, that falls under copyright. Now, how does copyright relate to fintech? In that most financial services met by fintech companies is through the use of softwares. And these softwares are simply a set of computer programs that are written by developers that initiates certain actions upon the input of data. Now, one thing about these softwares is that they are uniquely written. And when I say they are uniquely written, I mean that every financial technology company that is writing their own software has tailored it to meet their needs. And these codes are regarded as copyright because they're under the categories of work that are eligible for copyright protection. So now, when these fintech companies have their copyright, they're entitled to protection to prevent unauthorized third parties from using such rights. An example of copyright would be source code. Now, to move on, the author of the copyright, like I said, is the only authority to do or allow specified activities that has to do with that right. Now, when it comes to registration of copyright, it varies based on different countries, but then every country has their own registration requirements. in Nigeria, the ownership of copyright in a code vests first in the author of the code. And then if it's for employment, when you have employers and employee, if the employee writes such code in the course of employment, the copyright vests in the company, which is the employer. But for independent contractor, we find out that it is actually different. It actually vests in the author of the copyright or the author of the code, only if there's a written agreement between the employer and the independent contractor that, okay, this copyright should vest in the company. Second, we have patents. When we're talking about patent is an exclusive monopoly that is granted by the government to an inventor for his or her invention that is for a limited period of time, which is usually 20 years. Now, we can say, okay, how does patent also relate to financial technology? So now technology is driven by both invention and innovation, because this invention, they solve technical problems, and then these technical problems, they lead to like a great deal of skill, time, all these things that all these financial technology companies, they use. So the government, through the grant of patents, they offer these inventors of novel and industrial applicable inventions the exclusive rights to exploit and benefit economically. I mean, who doesn't want to make money? So if I am the inventor of a patent, and then, okay, I register my patent, I have that right to use my patent for my own benefits. And one thing we need to know about patents is that we know that, okay, copyright is the expression of the code, but patent is actually the process that is associated with the innovation. That process can only be protected by patent. It gives the inventor exclusive rights to use it, and then it prevents unauthorized third parties to also reproduce and exploit such invention. And then another thing we need to know is that also patent, the requirements for registry patent varies from the different countries or different governments. However, in most countries, for a patent to be registered, it must be new, it must involve an inventive step, and then it must be capable of industrial application. Then ownership of patents. The ownership of patents vests in the statutory inventor and not necessarily the actual inventor of the invention. Remember when I said, okay, copyright vest in the author, but for patent, it is who registers the patents first. So that's why it is advisable for financial technologies companies that have their own inventions to keep it a secret until it is registered, because you don't want anybody taking it. And if a person should register it first, then sorry, it is gone. It is now theirs to use and exploit. Then we have trademark. Now, for trademark, we see trademark a lot, but we don't really take notice of it. These are like marks, logo, slogans, and all of that. These are the things that form a business. They form the goodwill of the business. And they're also things that they actually help the business a lot. And how it relates to financial technology is that every financial technology company, as much as, okay, it is offering services, is also looking for ways to maximize their profits. Who doesn't want to make money? So now, this thing is that what do these companies do? Is that once they have a slogan or they have their logo that makes them distinct, that you say, okay, this is associated to this company, you look at it and then this is how they make their money. Is that a strong trademark allows the fintech company to set their products apart from their competitors. Whose company has whose logo, whose company has whose slogan. And we see it a lot in Visa, PayPal, Alert by Wema. All of these are under trademark. Trademark lasts for 7 years, but it is actually renewable. And then for registration of trademark, a name, logo, slogan, color can be trademark. So far, it is distinct, it is not descriptive, or it is not deceptive in nature. And then one thing about trademark protection is that it prevents another company or another third party, unauthorized third party, from using such trademark for passing off. That is when, okay, I have my own logo and another person unauthorized wants to use it. People know that it is my logo. So if they use it, they will think it is related to me. So if I've protected my trademark, it prevents such party from using it. Then for the fourth, we have trade secrets. So trade secrets is more like information that you want it to be confidential. You don't want it to get out. So now how it relates to financial technology is that most of these financial technology services, they make use of softwares, which are like written codes. And if all these things should become public, what is now the main use of it? Because now everybody knows it. So now all these service providers, they won't want to make it public because that's their main means of service delivery. And then these confidential facts, these trade secrets, is what gives them an edge over their competitors. This is what they use to make their money. So why would he just be left out in the open? But then the funny thing about trade secrets is that it does not require formal registration, but financial technology companies are still to take measures to keep them in confidence. And one of those measures could be NDA, a non-disclosure agreement with potential clients, investors, contractors, in that, okay, if me and you will sign an NDA that you're going to be private to certain information that is valuable to my company. So you are not allowed to say it out loud. You are not allowed to tell other people. If not, there are going to be consequences. And there can also be enforceable data security policy that will restrict access to certain information only if it is on a need-to-know basis. Then we have industrial design. Sorry, I have not been taking these slides. Then we have industrial design. What is industrial design? These are physical outlook of products that is offered by a company. And then how it is related to financial technology is that it is rendered with the use of both software and hardware. And this design could be by means of electronic cards, transaction devices. And they are very important because they are protectable IP assets of the fintech companies. They help to also protect the distinctiveness of the trademark or the product, that that, okay, this is associated to this company, this is associated to that company. For registering industrial design, it is also subject to certain requirements, but it varies based on country. But the most that most countries ask for is novelty. And then when it is granted, unauthorized third parties are prohibited from making similar designs in that product for a period of not more than 15 years. Those are the intellectual property rights that are very relevant to financial technology. Now, what are the benefits of IP in fintech industry? It protects and preserves unique services and products. It preserves it in that, like I said before, it gives the fintech companies a competitive edge over the other. Okay, that I know that this is for my financial gain. This is for my own company. This is something that I know that it gives me an edge over other companies. Then it provides revenue. Once again, financial technology companies are also companies that would like to make money. So it provides revenue. If these rights are protected, then it is for them and for them only. Only if they want to assign it or license it, in that they can make money by using their intellectual property. Then there's also economic benefit and financial advantage. There's an increased value for investment and acquisition. If most investors see that, okay, these fintech companies, they have intellectual property and they've protected their intellectual property, it makes an investor want to actually invest in such company. Then I'll go to companies that have benefited from maximizing their intellectual property. There are 5, but I'm going to touch on 2. We have cryptocurrency payment network. So the US Patent and Trademark Office approved Square Incorporation. So the Square Incorporation, they have a patent, which is a system that allows merchants to accept cryptocurrencies alongside conventional payments methods, and it also cash out in their currency of choice. Then we also have Bank of America, which is their patent of digital passport with verified data provenance. All these patents, it gives them exclusive rights to use such inventions and innovations to their own use. Therefore, make sure that their profit is maximized. Then for fintech companies that have lost revenue as a result of not maximizing their intellectual property, there is Wingo Card and there is Bolt Mobility. In conclusion, companies should clearly define and protect their intellectual property with registrations and documentations, especially when working with multiple third parties. Okay, for trade secrets, you have, let me use trade secret now. Okay, so we've signed an NDA. I'm protecting my intellectual property. You're private to it. So, okay, you're not allowed to disclose it. And then fintech companies will then control use of the intellectual property rights, including permitting use under licensing and collaborative arrangements. The fact that they have exclusive rights to the intellectual property, they also have the rights to say, okay, I want to assign my intellectual property to this person. I want to assign my intellectual property right to that person to make sure that, okay, yes, we're also making use of it. We're also maximizing profit. So it is advisable for financial technology companies to have intellectual property rights, to register their intellectual property when necessary before they can actually get a very good start and make the most use of their services. Thank you.
Thank you so much. I was almost trying to remind you that our time was almost up. Thank you, very wonderful presentation. I'm sure the AI group is ready to proceed. Group Team AI, are you there?
I think the presenter for AI is Bambose Towobola, and the backup presenter is Tolu.
So is Bambose on the call, and is if the mentee is not on the call, we can have the backup presenter. Let's see how we can do this very quickly so that we can have enough time to engage further after the presentations and also during the Q&A.
I can't see the both of them. Okay. Can't see the both of them on the meeting. I don't know. Anybody from group AI group 1 can present on behalf of group 1 AI.
So is there anyone else that can get right in and do some magic for us in terms of the presentation for the AI group? I followed through on the AI presentations from the last couple of weeks, and it's been very interesting listening to the engagements during the AI program. So it would be nice for one person. You don't have to be the team lead or the backup. If you have an idea of what the presentation was really about, you can take the bull by the horn. So do we have somebody from the AI team AI?
Can you help us, group 1 group leader, Oluwabusola, I think.
So what I think we can do now, we are still awaiting our mentors to join us. I'm just trying to look through the participants on this call. So in the absence of group 2 at the moment, what I think I can do would be to just make a few comments on the first presenter's presentation while we await group 2 to put its house in order and to give us a presentation. So very quickly, what I would say in passing, not even in passing, but what I would say generally speaking is that the presentation was actually a very nice one. Having to marry what FinTech is really about to how intellectual property impacts on FinTech company transactions is one very interesting thing. The challenge most of the time that a lot of startups have basically is a scenario where the bank wants to be the bank, the bankers want to be the bankers, the pastor wants to be the pastor. Everybody should be able to, when you are a founder or you are a co-founder, don't assume that you understand everything about how your business is actually going to operate. For example, you can meet certain tech people, they know about how to write codes, they do all of those things, but they necessarily might not know how those codes, how the law interfaces with the codes that they write, the softwares that they come about, and all that. And that's where copyright actually has, to play a lot of role in that particular sense. So when you talk of, she mentioned written agreements she mentioned stuff around the software codes. So basically, if you have a contract of employment, it's totally fine, so that you can actually be sure that when somebody says, somebody doesn't wake up tomorrow and say, okay, I came up with the entire code, so the codes are mine. That means the company now ceases to exist. You don't want to be surprised. So you must, as a startup, as a fintech startup, understand how intellectual property has a role to play in your company, in your business. In terms of patents, where patents are required, if your company is such that you require a patent, because not every fintech company might require a patent to be done for the company. So where that is in place, it's important for you to reach out to people who really understand how patents work. And I can tell you for sure that within the Nigerian space, not a lot of people even know how patent drafting actually works. Not every lawyer understands what patent is really about. So it's your responsibility to look out for, specialized lawyers that understand what a patent is really about and how to go about patent registration. I know that for patent drafting, it's actually an expensive venture. It's not cheap to have somebody draft your patent application. So that would require a lot of patience, a lot of resources on your own end to be able to get the right person to actually act as a plug, for your patent application. Then I've also found out that trademarks are by far the most popular of IP rights that fintech startups engage in registering. And the reason is because it's almost also the most talked about. You have PayPal. You cannot mistake PayPal now for CUDA. Same way you cannot mistake Paystack for other payment applications that we have out there. So the trademark, very, very key. I actually encourage a lot of companies, especially fintech companies, to really get trademark lawyers that understand trademarks. The beauty of some of these things basically is that you have a lot of in the legal space. You have a lot of people who feel like they can venture into every area. You must be willing as a fintech startup, look out for specialists, IP specialists that understand what trademark is really about. As simple as trademark might sound, not every lawyer actually has an understanding of what a trademark is really about, what are the trademark and all that. So trademark has about it has roughly 45 classifications. The main classification for trademark that relates to fintech companies is about electronic payments and all. So if you're a fintech company and you want to actually get your trademark done, you might be looking primarily at class 36 for the trademark classification, and also you can also be looking at class 9 as well. So if you want to cover the field as far as your trademark application is actually about, you might go beyond just registering under class 36 and also include class 9 to your trademark classification. Then also for trade secrets, you need to engage with a lawyer that actually understands what a trade secret is. And one of the ways to really protect yourself is to also see how you can have the proper agreements in place. You need proper agreements in place. You need the non-disclosure agreements. You even need a confidentiality agreement. You need a founders agreement. You need to put certain clauses, even within the founders, because you don't want one founder to now sabotage the other, maybe when disputes arise and all that. So within a founders agreement that you are writing or you are preparing for maybe the founders of a fintech startup, you need to also have what I call the founders agreement, and that agreement has to factor in non-disclosure clauses, confidentiality clauses. Then also in terms of employment, for example, you need employment agreements that also cater for protecting the trade secrets of the company in question. So that's actually very important, very key. Industrial design, it's still one thing, especially like if you look at all these POS devices, most of those devices are actually covered under this particular IP right, industrial design. And sometimes you look at a POS device for maybe money. You also look for at the one from UBA or from Zenith Bank or from GT Bank. You might also realize that most of these POS that we find around, the designs vary. They might look alike, but there are sharp differences in the way the designs actually come around. So I think that's all, at least for now, for the first presentation in terms of my overview of what the presentation was really about. But by and large, I must say that you touched most of the very key areas in that presentation, and I can say that the presentation was actually a very good one. Thumbs up to the FinTech team. I'm happy that you're able to understand, how IP, can interplay or can engage with, FinTech in a way that, FinTech companies have to realize that IP is actually something that they need to put into consideration going forward. So I think that's it. I don't know if who is actually
I'd like
ready.
to add something to.
Okay.
Yes. So you've already touched most of the points that I wanted to raise, but I'll just like to talk about since we're talking about FinTech, most of them are online. Some have domain names and all that. So it's good to also look at it from the trademark perspective also. So where there are issues with the domain names and where there are similar names, because now we see like a name like Paystack and we see another name like PayPal. So that can be confusing, but we have seen so far that the FinTech industry, they are not so conscious about some of these things. So for example, there is a shop close to where I stay, and the name of the shop is Skylark, and then we have another one that is Cyplac. So they are very similar. Those names can confuse a customer. So what trademark is supposed to avoid is confusion with the customer and trading the goodwill of a client for another one. So for the FinTech industry, we have seen Paystack, we have seen PayPal, we have seen, I think, Kuda, then I think there's another similar name to Kuda. So it's important that when you have a client, you try to encourage that client to distinguish the name that they use so that it can be distinct from the name of another person in the same industry. So if the FinTech class is class 36 or is it class 39, I'm not so sure. What you should be advising your clients is to be sure that no other person is using a name as similar as their name. So they should try to look for something that is distinct. Then another thing I want to talk about is the territoriality of an intellectual property registration or right. So for trademark, it is territorial. Patent is territorial. Industrial design is territorial, meaning that if your name is registered, for example, in Nigeria, in Kenya, in Ghana, another person can register that same name in that same class in another country. Meaning that if you have a client that registers a trademark in Nigeria and the name of the trademark is Paystack, another person can start with that name and register Paystack in Kenya. So if you have not advised your clients that they should identify the countries which they feel they would have most presence in and go and register in those countries, they might have a competitor with the same name in another country. And then you now have a domain name issue when maybe you have a paystack.ng and then you have a paystack.com or a paystack.kenya or a paystack.South Africa. Then you have a confused client. So while advising your client, you should also advise them about the territoriality of registration and for them to decide what countries they want to register in. Also, trademark has to be renewed, as was said by the presenter. So once you see that the time is approaching, you also have to encourage your clients to renew their trademark registration. So for industrial designers, Mr. Joseph has already spoken about. So the 2-dimension and the 3-dimension, that can also be used online. So maybe the way the website looks, the way the site looks, like the outlook of the site and all that, that can also fall under this, but it has to fall under like something that is unique and novel and all that. But the example that he gave, I think, is like the perfect example. And then for trade secrets, it's something that is really important also. And he has already touched it from different angles, but also good to know that some of the things that can fall under that, like your client list, that should be kept private. Even aside from even the trade secret part that is even attached to that, there's also like the data privacy part and all that, but like your processes, the way your site works and all that, those are things that fall under your trade secret and should be kept secret. Then also, when you come to mergers and acquisition, where you have maybe 2 different fintech companies that are trying to merge, you also have to think about valuation of the trademark, valuation of the IP. That is part of the things that are being valued to help in the merging of the 2 companies. Then also in how much should be paid, like for those who start up their fintech companies to sell. By the time they are ready to sell, they also have to value the IP too. That is also part of the things that will also be considered. So if you are a lawyer here, and it's good for you to have a background knowledge of intellectual property, because it will help your clients not just in the internal running of the business, but also when they are reaching out to those that will fund their companies and all that. So as an attorney, try to also understand what IP is about. Then also try to know the durations of this IP. What are their durations? For example, when you're registering a computer program, you have to register it under a copyright. But if it's solving a unique problem and it's something that is novel, then it can also come under patent. But if it's coming under copyright, then it will be registered as a literary work. So if it's registered as a literary work, then it will be for the lifetime of the author and 70 years after. So, sorry, my baby just came. So these are some of the things that should be considered. Thank you.
Mr. Joseph, are you with us? Thank you very much, Ms. Juliana and Mr. Joseph, for stepping in on behalf of our mentors for today that were absent. Okay, Mr. Joe, you can.
Yeah, so I was thinking group 2 is ready so that we can take their presentation. Team AI, is Team AI on ground? Can we look through the participant list to just find out if, I'm just trying to look through if we have, is the AI team, is it Grace Bamigboye? Is she part of it? I don't know. Mr. Hussein? Hussein, are you there?
No, Grace, no Grace, no Grace.
Okay.
I think their backup presenter is Mahmoud Aishat Abike.
So it means none of them is around. Is anybody in the sorry?
Team AI, right? I think I called the group leader earlier on. She was with us.
Well, I think that if you're not ready, we can just move to the question and answers.
I really feel it would have been nice to have somebody from that team to just give us, even in few short words, what their presentation was really about, so that we can look it through even in few minutes. But if they're not available, then we have no choice but to move to Q&A. Because it would have been nice for...
I'll be asking you questions. So Mr. Joe and Ms. Juliana will be answering. So Mr. Joe, you will be taking the FinTech questions. Yes?
Sorry, Hussein, please, let's not forget the picture time.
Okay, yes. So before the questions, I encourage everybody to put on their videos. I'll be taking a snapshot immediately before we move to the question and answer. Okay. Please, if you are in the meeting with us, you can turn on your video and smile. It's a good day today. It's Friday. Tomorrow is the weekend. We are going to have fun. Just look for any small thing to make you smile. Thank you very much. I'm seeing only 3 people. Please, mentees, you can do better than this. Kindly turn on your videos. Want to see your beautiful faces and your handsome faces for the guys. Thank you very much, Kingsley. I can see your video is on. I think the turn up is still very low. Yes, we can all do like Mr. Joseph. I think he has been smiling for over 2 minutes now. Yeah. Yeah, that's how we want it. Okay. And I think I got one screenshot, so we can go with that. So I'll be posting the questions on the chat box.
All right. Do we have a live question?
Yes. Okay. Yeah. So anybody that has a live question, you can kindly raise your hand, and I'll call on you to ask your questions. So our both backup mentors for today. So yeah. So the question for FinTech is going to Mr. Joe. So where a particular FinTech company has gained goodwill over the years of a particular trademark, but does not register, and a FinTech startup that just came into the market registers that trademark, how can the FinTech company who has gained the goodwill of the people avail itself in that kind of a situation? Did you get the question, sir?
Yes, I did. I actually got the question. I'm just looking for an analogy to be able to answer that question. One thing that we should bear in mind basically is that, especially when some of these kinds of cases get to court, you'll be shocked that there are always 2 sides to every story. You know, you would have a lawyer on one side saying that, okay, our client has been using this name, they've not registered it, blah, blah, blah. The other lawyer would say, our clients just started business, they love this name, they have actually had this name. Because the challenge will now be, how can you prove goodwill? How can you prove goodwill in the absence of a registration? You know, that's one question that you would need to be able to ask yourself. You know, and like I know for trademark, basically, the way trademark actually works is the person that registers it. First to register, that's the way trademark actually works. So for this kind of a particular company that has gained goodwill, they would have to prove how their goodwill will usurp an already valid registration that is in place. You know, because for trademarks, how trademarks work also, and this does not just apply to FinTech companies, it applies to a whole lot of companies. Even after you get your acceptance, you know, in the trademark process, you have the acknowledgement phase, the acceptance phase, then the publication phase, then you also have when your certificate will now be issued. Even after you have gotten your acceptance, somebody that still feels that their name is still very close to yours, they can still oppose that name. They can still oppose that name, you know. And in opposing the name, sometimes you might now have to now end up at the trademark tribunal and all of that. It's a whole lot of process. It's an expensive process as well. So for those that are banking on goodwill is not enough. You have to move beyond goodwill. You have to register your trademark. It's very important. You know, some people also confuse it with CAC registration. CAC registration and trademark registration, they are absolutely two different things. In fact, to really show their difference, they are I don't want to use the word regulated, but they are overseen by two different government agencies. CAC is to Corporate Affairs Commission. The trademark is to Ministry of Trade. So there are two different organizations that, you know, oversee trademark and company registration. So it's my advice that once you are sure that you want to engage in a business, you want to do fintech business, before you start even running ads and doing a lot of things, you also still have a lot of other regulatory issues. Rule number one, get your company registered. Rule number two, in fact, as you are still registering, once your registration is going on, the best next thing to do is to start your trademark registration. It's extremely important. So don't joke around it. Don't joke about it, so that it doesn't turn around to come and hurt you in the future. In fact, there are even people that register trademark that they don't even need. They look out for some of all these companies that don't see trademark as something that is very useful. At the end of the day, I know it's very popular in some foreign countries. People just go around registering a lot of things, then they come and ask you to stop using it. Then you will now have to now buy off the rights to that trademark from them. You don't want to find yourself in that kind of a situation where you are now the one, you know, something that you've been using for too long, you now have to go and purchase it from someone else and all of that, you know. So it's better to always engage rightly and do things right as far as your company is actually concerned. Don't take some of these things too lightly. It creates more problem in the future than good. Yeah, so that's my response to the question.
I might also add something to what you've already spoken about. So what that company is banking on is that's the common law, goodwill and all that, which is not sustainable. So they can bring a case through like passing off. However, what I know
I can't hear Miss Juliana. I don't know. Can you hear her?
if the Coca-Cola now, and somebody now brings that name to register a fintech company, even though Coca-Cola is not registered as a fintech company, they would most likely not grant that person a trademark registration because there is already a notorious player. Sorry, let me know if you can hear me.
Yeah, we can hear you now.
Yes, but if your name is, but if you are not a notorious person that the trademark registry will know you and all that, please just go and register your trademark, because by the time someone else goes to register it, then you will now have to start proving how you have that goodwill and all that, and they might not give it to you, though it will be at the discretion of the judge, but it's about the first to register. So please, if you have a client, advise them to register it and not lean on the common law passing off. Thank you.
Okay, I can see that we have two mentees that raised their hand. The first mentee is Oladotun. Oh, so you can ask a question, and Angela Oluwa can also ask a question.
Good morning. Sorry. So Mr. Joseph said something about getting a trademark lawyer that is really knowledgeable in the area So I was wondering, as a young lawyer, quote and unquote, how do you become particularly knowledgeable in one area? Because many times in like pushing your career path, most law firms are like looking for someone who can do virtually all areas of law. So sometimes it's very difficult to streamline your career path to one particular area. So how can you achieve that? That's my first question. I have another question. Before I continue, please, I would like to say that I'm very grateful to Gypsy for combining our classes today, because I observed that we're having FinTech and AI class together today, and it has been very impactful for me, especially. So that's really commendable. I would like to say that. And also, I'm from Group 2 AI team. So my second question now, how, as a consumer, when there is an intellectual property infringement, maybe for example, the other day I was trying to buy a drink and I just picked up what I assumed to be Fanta, and upon getting home I realized it was Finta, and I was like, what is Finta? Like, how is there a company that is named Finta? Like, that's just very wrong. That's like serious passing off and copyright, or no, I think trademark infringement. What can I do as a consumer? Because I feel like it has affected me financially, and it can also affect my system. So can I bring an action against the fintech company, or is there anything I can do as a consumer who has been affected by intellectual property infringement, any kind of infringement? Thank you.
So sorry you had to. I hope you didn't drink the Finta.
I did.
Yeah, so sorry about that, because it's really strange. I personally haven't come across that kind of, especially for beverages and drinks. I don't know how that passed, because that would have had to have gone through the trademark process, except that company has actually not been able to trademark that particular name. I don't even think they can actually trademark that name. So I just believe that is one of those bad guys in the business. Well, let me quickly respond to your first question. How do you become knowledgeable in one area? The reality is that as a legal practitioner, the truth is you cannot just say, except for some people that have the grace for it, especially now where everybody is looking for multiple streams of income and all that. That is also affecting lawyers across board. So that's why you see that most of all these very big wigs, the senior advocates and all that, they are necessarily not just doing one thing, they are doing a couple of things, so, but it's good to be known for something. So the only way you can become knowledgeable in one area, there are certain lawyers that actually, they're IP lawyers, like that's their forte, that's their stronghold. If you bring a case on maybe breach of contract, for example, they will definitely be able to still engage with you. But as far as IP is concerned, that's one thing that they are known for. Like in Lagos, for example, there are some maritime companies, some maritime law firms, oil and gas law firms, energy law firms. That's exactly what they are known for. But there are certain other areas of law that they
Sir, you are no longer audible.
Okay, sir,
Right.
you have been muted.
Oh, wow. For how long?
Like maybe 30 seconds ago.
Okay, yeah. So the summary of what I've just been trying to say basically is that every law firm needs to be known for something. I think is actually very important. Every law firm needs to be known for not something. It was in the past where you can really thrive on jack of all trades syndrome. In fact, most of all these big law firms, they have the IT decks, they have the energy decks, they have the maritime decks, they have they have a lot of practice areas. It's most of these firms too is not really like maybe they are a jack of all trade kind of a law firm. They have specific people that are manning specific areas in their law firms. So I will encourage as many people who have an interest in intellectual property. You might need to study around it. You might need to start engaging around it a whole lot. And also for practical purposes, for lawyers, basically, you have to put yourself out. Sometimes you don't need to, you don't necessarily have to have all the answers as far as IP is concerned. You just put yourself out there. Okay, you want to now begin to deal on IP related issues. Not necessarily saying, okay, you are like an IP lawyer of 5 years, no, but you want to start dealing on IP issues. So in that respect, people start asking you questions on IP. As they engage with you, you engage with the industry, you engage with the regulators, you engage with your colleagues, you begin to get a whole lot of information. Along the line, you become an expert after a number of years, as the case may be. So I feel that that's one way that you can really hone your own skills and become better in your own practice area of choice. The fact and the reality is that every lawyer, there's no lawyer, I'm yet to see a lawyer that would tell me that they can engage in every area of law. I'm yet to see that kind of lawyer. You say you're an IP lawyer, you're a business lawyer, you're an energy lawyer, you are a FinTech lawyer, you are a patent lawyer, you are a space lawyer, you know, you are a transport lawyer, you are a construction lawyer, only you, one person. You want to kill yourself now. Even when they say lawyers know the law, you know, we know the law, but that doesn't mean we know every area of the law. So I've been told, I think I saw that Mr. Marks has joined us. Mr. Marks is a formidable force, you know, to reckon with as far as IP is concerned. So I would just like to introduce or to bring Mr. Marks on to share some of his thoughts along the lines of the questions that we are already having. So Mr. Marks, please, if you don't mind, kindly take the floor as I exit. I've been sitting on your seat before you came in, but since you are here now, it will be inappropriate for me to continue speaking on an area where I still feed from the crumbs from your intellectual table, sir. You are welcome.
Thank you very much for this kind words, Mr. Joseph. My apologies, actually. Unfortunately, I'm in Accra for a conference, and because they are 1 hour behind, you know, so when I even saw the message that the meeting was starting by 12, unfortunately, because it's still 11 here, so I just didn't make that adjustment on time. But thank God that Ms. Juliana gave me a call, and that prompted me to really check my time properly. So I apologize for joining really late. I was really enjoying all you were saying, Mr. Joseph, and I think you should have just continued, you know, and not brought me to the conversation. But I mean, it's always a delight to be, you know, on the JIIPCC, program, you know, discussing these issues. And I just want to start by agreeing with some of the things you have said, that, yeah, you know, the days when lawyers were jack of all trades is long gone. I mean, if you are going to be a jack of all trades, then you are not really ready to build a proper career, you know, when it comes to the modern practice of any area of the law, particularly IP law. I mean, even within IP law, we are getting to a point where people actually specialize even within IP law. So it's even beyond just saying my law firm is going to be an IP law firm. So you could decide to look, we just do copyright licenses alone, and that is a huge area. Even though that's even a subset of entertainment law, you could decide to just do pharmaceutical patents. That's a huge area on its own. You could decide to just do IP in sports, merchandising, product, product development and all of that. So there are all kinds of huge areas. Of course, in our own jurisdiction in Africa, and particularly in Nigeria, our markets may not yet be ripe enough for that, you know, that level of specific specialization. But you could do what I call a thematic focus. So, for instance, my law firm has a thematic focus on you know, as far as we're concerned, on commercial law. So we do a lot of things, but we try to tie all of them to commercial law. So I mean, IP, we still do a lot of regular litigation, but as much as possible, focus on commercial litigation. So even if we do a labor law disputes, for instance, typically there are labor law disputes connected to, you know, commercial organizations and all of that. So I would, for instance, not do a litigation that is a trade union litigation, pure and simple, because it's not exactly my kind of thing. But I might do an unfair dismissal litigation because it involves a company, maybe not a government organization, not unfair dismissal of a public servant, for instance. So it's more like a thematic focus, but like you said, rightly, we may not exactly be there yet, but the focus is to get to that point where even within the law firm, people really specialize and own their craft in a particular area and really become specialists in that area. So having even what we call a full service law firm is no longer really what it used to be in those days, where the same law firm is handling a criminal litigation, and then the next day they're handling a maritime dispute, and after that they're handling a chieftaincy dispute. After that they're handling a land related dispute. So I mean, few law firms actually have the muscle it takes to do that and do it well. That's really the point. So like I always advise people, if you are interested in the field of IP, begin to think about the industries where IP plays. So like I mentioned a few of them, pharmaceuticals, for instance. Without IP in place, pharmaceutical industry actually will die off, because the kind of investment in research and development that pharmaceutical companies have to make in terms of developing new drugs and all, if there's no patent system to ensure that they can have a monopoly to make back, a return on investment on those research and development funds, then even banks and funders will not be willing to advance money to spend, to expend so much in developing those developing those drugs. So that's one industry where IP, without IP, that industry will not survive. So I mean, if you are interested in looking at a subsector to focus your effort on in IP, that would be one good area to go into. Sports, for instance, is another area where without IP, sports would not be what it is today. I mean, a few years back, if you are a person who follows the sporting industry, maybe football, for instance, if somebody was signed for $80 million, it would have been a record world-breaking transfer news that somebody has been signed for $80 million. But we've come to a point where people have been signed for $100 million and all that, and it's no longer big news. That is because the model for sports before did not incorporate as much of IP into generating other revenue streams. So streaming of sports content online and all of that, merchandising for and sponsorship deals for the players themselves. But because IP has come into that sector now, IP now makes it possible for somebody like Ronaldo, for instance. We hear that the greater chunk of his revenue is made from his endorsements and from his activity on Instagram, even more than the salary he's paid by the sporting club. So you find out that the greater chunk of the commercial income coming into the sports industry is coming from those things that are dependent on IP, product merchandising, broadcast rights, and all of that, which are all IP connected. So that's another sector where IP is playing a huge role. Of course, another sector will also be in technology, primarily because when it comes to technology, one of the things that happens in software, for instance, is that the idea is that because when it comes to software, the speed of reproduction and the way you can reproduce a software or a digital asset is really easy to reproduce at a high rate. So without, for instance, the law of licensing, for instance, software would almost not work. So you can see that's another area where IP has become a key cornerstone. So the revenue models for any successful technology company, you see that their IP plays a huge role in that. So these three areas, for instance, at a basic minimum, if you are thinking of going into IP, of course, like I said, our markets are not mature enough yet where you exclusively focus on those areas, but continue to think of evolving, say, in the next 10, 15, 20 years of your practice where you can actually hone in on one of these areas and stay on that alone. There are already people who have honed in on some of these areas, and that is all they do. So one of the mentors who came on earlier, Mr. Mobi, for instance, is a sports law specialist. So he does just sports law. I mean, that is where he stays, and he's doing well. He's making a lot. So you could actually begin to think of it from that viewpoint. I mean, you might not start with that immediately, but you should have a plan to say, look, in a couple of years, I'm going to focus in, I'm going to become a specialist in this area. I'm going to understand the transaction dynamics in this area, and I'm going to play in that area. And it's also a very good model to take to the IP. But just doing IP and doing everything, patent, trademark, copyright, and all, I believe in a few years' time will no longer be fashionable and will no longer even be profitable or realistic anymore when our markets mature enough. So with those points, I'll just hand back to you, sir. Thank you.
Thank you so very much, Mr. Marks.
Mr. Marks,
it's been a lot for personally. So, Mr. Hussein, I think he has another question for you. I'm sure that you have an engagement at the moment. So.
No, but I'm here, please. So please feel free. Any
before the
questions?
question, I think we still have a mentee. Her hand is raised up, so I'll call on her to just ask a question, live question. So Angela Olua, you can ask your question before I take the questions that were sent before the session.
Okay. Hello. Okay, thank you very much. Please, can you hear me?
Yes, we can hear you.
Yeah, I can hear you.
Okay, please. I actually have two questions to ask. One of them is that for a young professional who wants to delve into intellectual property, how can the management help in getting a law firm into intellectual property to have the enough exposure in intellectual property? Then the second question is, please, how can we get assessment and documents required to the assessment and documents required for the registration of copyright, trademark, and patent design? So those are the two questions. Thank you.
Okay, yeah. Thank you, Angela. I believe I can call you that for those two excellent questions. So yeah, so for the first question, looking at how a young IT practitioner can really break into, like we've mentioned, I mean, the Nigerian market is not so deep yet where we have too many law firms that are focused only on IP. However, we have a few really good law firms. So what I always encourage people is, if you are still a student, for instance, then you should be looking at doing an internship with those law firms. I mean, doing ASU strike, or the little break in between you have from the academic session. You should look at going to those law firms, pencil them down, and just say, look, I want to have do an internship with you. Of course, for some of those things, you should be ready to make sacrifice, saying, look, I'm not ready to be paid anything. I just want to come here and just learn and see how these things work in practice. So there are a few of them that are very good. Then another way to actually know where to get them is to join some of the professional associations, or at least their events. So for instance, the Nigerian Bar Association section on business law has an IP committee, and they have a lot of events. So they have webinars, they have seminars, they have conferences and all of that. So at a base, at least you try to join. I mean, of course, you if you are not yet qualified as a lawyer, you might not be allowed to join the committee, because committee is only open to lawyers who have been called to the bar and who are members of the Nigerian Bar Association section on business law. But what you could do, for instance, is to get on their mailing list. So whenever they have an event, you get a notification and you can attend that event. While you're at that event, you have the opportunity to network with some of these law firms, and you begin to ask them, look, I want to have an internship with you. I want to spend some time in your law firm just to get more experience along this line. So that would be one good way to go about getting your foot in the door. And then it's easy, if you perform well during your internship, to get an offer. I mean, typically, for most law firms, they see you perform well because IP is still a relatively not very saturated area. So if they see you perform well during your internship, the chances are you wouldn't even have to ask. They'll be the ones to begin to track you and say, as soon as you're done with law school, we want to have you come back and join the team on a full-time basis. So please look out for internships. Of course, joining JIIPCC, of course, is the first step. You're having a lot of mentors coming. Like I tell you, see people like Uche and Wokocha, for instance. Those are people you should hold tight on to. Keep following them on LinkedIn. Keep chatting them up anytime you have the opportunity to, and just keep that relationship close. That becomes, an easy way to get your foot in the door so far as IP practice is concerned. Then for your second question on how to get the documents, the forms, and necessary to register, the good thing is that they're all online now. So for instance, for copyrights, it's I'll try and chat up on the chat box, put the website for the copyright registration portal. You could go there. All the requirements are already there. Really easy, simple to use. Same thing also with the trademark. There's a IPONigeria.com. You go there, all the requirements to register trademark, patents, and industrial designs are already on that site. I mean, of course, particularly with the trademark and designs site, you have to be careful because some of the details are not there. And like I tell people, it's for good reason, because when it comes to registration, there are a lot of technical details involved that you just don't find on the surface, and it takes some level of experience to understand all of the requirements. Because when it comes to trademark, for instance, you have to know how to read the NIS agreement to understand how to classify the goods or the services that the person wants to register a trademark over, to know what the appropriate classification would be. So it takes some experience, but I mean, all these documents are available online. So even a simple Google search, how to register a trademark, will pull up some of those documents for you. And of course, like I said, you already joined the JIIPCC, so you already have your first foot in the door, and you already have the opportunity of knowing a lot of these things. But just ensure you stay in touch with the mentors, chat them up on LinkedIn, try to get their WhatsApp numbers, and just be in touch whenever they have events. Of course, attend the events. That really helps to make you visible in this space. So, Angela, thank you. I hope I answered all of your questions.
Yes, sir.
Thank you very much, sir.
Thank you.
Thank you very much, sir. Mr. Marks, I think the last question you answered for Oladotun, that was the first mentee. I think she asked 2 questions. I don't know if you got the second one. So she's like, a second question has not been answered. And the question is, what is the right of a customer who has suffered from an IP infringement? And I think she gave an example of Finta and Fanta.
Oh, Finta and Fanta.
I think you can also,
excellent question, and it's a good point. Now, I always make this point when I speak to people about IP law. That, IP law, okay, just to go back and give a broad background. Now, we need to understand this. The economic system that the world largely runs on, even for the countries who claim they do not. And by that, I mean Russia and China, who say they are socialist systems. Whether I like it or not, largely the world runs on a capitalist, what they call a free market model. So in a capitalist or free market model, one of the underlying assumptions is that competition between enterprises is good for the consumer. So competition law actually is one important pillar on which the global system of the world runs, that companies and producers of goods and services should to fully compete the market. And in the course of competition, number one, it will drive prices down because when you have competitors who also have the same goods and services are available, then you want to give the best price to win the market. Secondly, you also understand that because you have competition who also can produce the same goods and services at maybe a better price, you also want to increase your quality so that you can keep your edge in the market. So this is the foundation on which the world is built. Now, IP system is almost a negation of the principles of open and free market and competition law. Because in patents, for instance, you are getting a 20-year monopoly where none of your competitors can offer the same goods or services that incorporate that invention. So that becomes a negation of the principles of a free market system. So, but however, because nothing is ever absolute, so free market system is not absolute, because they also understand that people go out of their way, spend money on research and development to come up with new brands, new product, new services. They need to be given some protection to earn a return on investment before competitors are allowed into the market. But however, added to the free market system, the IP system is also consumer protection. Every government wants to protect its citizens. We want to ensure citizens get the best products at the best prices and safe products as well. So in Nigeria, for instance, the Federal Competition and Consumer Protection Act 2019 actually has provisions there that protect you beyond the IP infringement. Because when it comes to IP infringement, like the example of Fanta and Finta, the primary person who has been injured by that IP infringement is Nigerian Bottling Company or the Coca-Cola Company, the producers of Fanta. But for instance, you who bought that product, assuming Finta was not a good product, you took the product and you fell ill. Now, there's also some harm done to you beyond what has been done to Coca-Cola Company. So the Federal Competition and Consumer Protection Act also allows you as a consumer to take up a complaint, even though the IP infringe is not your IP. But as a consumer, you have been misled into buying a product or a service that is not what you wanted to buy. So under the FCCPC Act, you also have a right to bring a civil action. I mean, and that's added, of course, to the regular civil action in negligence. If, for instance, you took the Finta and you fell ill because they used excess coloring chemicals in it and all of that. So you could use your regular common law rights to bring an action in the tort of negligence. That's on one side. But beyond that, under the FCCPC Act, as a matter of consumer protection, you also have the right to bring an action under that. So, so beyond the Coca-Cola Company taking an action, even the consumer also could take an action for that misleading branding of Fanta and passing it off, as it were, as as Fanta. So yeah, so there are a range of remedies, but yes, for consumer protection, there's a new dimension to IP law where consumer protection law now has an intersection with IP law as well. Thank you. I hope I answered that very well.
Orlando, so I think you can answer Mr. Marks. He's asking if, okay, she sent a message on the chat box. She said, yes, sir. So thank you very much.
Thank you, Orlando. Yes, I just saw the chat from Orlando too.
Yes, thank you very much, sir.
Yes.
Thank you very much. We are so happy to have you on at the end of the, when we are coming to the end of the program. We still learned a lot. You still came in and you gave us a lot of insights on all our questions, and we are so happy. So quickly, we'll still be taking another picture. I think we took a picture before you came, but we still want to take another picture, and I want everybody to put on their videos. So I will take the picture quickly in 30 seconds. Please just put on your videos quickly. Thank you very much as you do so. Okay. Okay, yeah, I've got the picture. So quickly, I will be moving to the closing vote of thanks, and I'll be calling on Ms. Juliana to give us the vote of thanks before we round up the session for today. Mr. Jones, you can also give us any closing remarks before we round up the session for today.
Okay. Oh, all right. Very quickly, I want to say a very big thank you to the mentees. You've been exceptional since week 1. It's already week 5. You can see how time flies. Very soon we'll be in week 9, and it'll be game over for Q4. Thank you very much for your dedication, for your commitment, for your collaboration, and for your discipline. It takes a lot of discipline to really get these things done. For the AI team, we missed out on a very huge part of today's session. I just hope that the possibility could actually arise where we would actually have your presentation so that the FinTech team could also learn from an AI perspective as well. But aside that, I want to say a very big thank you to all of us. Thank you, Mr. Marks, for joining us from Ghana. I wish you told me earlier. I would have followed you as one of your apprentices so that I can also be part of that conference. Thank you so much, sir. We are very grateful. Mr. Hussein, thanks a lot for putting all this together. I know that the back end of getting things done can be very tasking most of the time. People don't see all that energy behind the scene, but everything that we are witnessing today, the whole thing that comes up at the end of the day has been as a result of Mr. Hussein's commitment as well. Thank you very much. I also want to thank Juliana for giving me the opportunity to be here today. It's a pleasure. I hope I've delivered as well. I just want to say that for much of what we've learned today has been very impactful. I would want to advise that as much as we can, kindly tag our mentor, tag Mr. Marks. You can tag me as well, tag JIIPCC. Just state what you've learned. Let us see how we can, put the word out there. And registration for 2023 Q1 is on. Tell your friends about it, post about it, and see you in week 6. Do have a very wonderful weekend, everyone.
Okay. Bye-bye, everyone. Bye-bye, Mr. Marks.
All right,
okay,
guys.
Thank you. Bye.
So
have
much.
A wonderful weekend.
Okay.
All right, sir.